The trust's professional responsibility fact pattern from February of 2002 is yet another problem that well could find a home in a remedies seminar. Let's have a look together. Turn to the call of the question. 1. What grounds, if any, under California law, can Brian assert for invalidating the trust, and what is the likelihood Brian will succeed? Discuss. Well, Brian is going to have one or more theories of liability, and we know his prayer for relief. He wants the trust invalidated. Well, there's a couple of ways to invalidate a trust. Either determine that it was improperly constructed, that there's something wrong with the formalities, or some indicia of fraud or undue influence or other tortious conduct. Next, turn to question 2. What grounds, if any, under California law, can Brian assert for removing Alicia as trustee and requiring her to indemnify the trust, and what is the likelihood Brian will succeed? Discuss. Well, this appears to be a question about fiduciary duties that may have been breached by a trustee. We know that trustees have duties of loyalty and care, etc. So we will examine the conduct of Alicia the trustee, and we will make some determination with regard to whether Brian will achieve the remedy that he seeks. Then, in question 3, we are asked, as an attorney, independent of her capacity as trustee, has Alicia violated any rules of professional responsibility? Discuss according to California law. Well, we have yet to do professional responsibility together, unless you are working outside of the order I suggest, but we've already seen professional responsibility in several of our seminars before this one. And we know the two basic approaches to PR are either organize around the duties or organize around the conduct. And we'll wait and see what the fact pattern gives us before we make a decision on how to do it one way or another. Still, our little checklist of attorney duties and correlated problems that can arise comes to mind. Fair enough. So, now, please turn with me to the top of the fact pattern and let's review it. This is a somewhat longer fact pattern than many wills and trusts questions, and it holds true to form. This is a somewhat easier question as a result. Still, we're going to have to find a home for a lot of facts under time pressures. Look at paragraph 1. Richard, a California resident, created a revocable inter vivos trust in 1998 at the urging of his wife Alicia, who was also his attorney. Alicia drafted the trust instrument. Well, if there's anything wrong with this trust instrument, or if Alicia has misled her husband about anything, there's going to be liability attaching and a chance that this trust will be invalid, or subject to invalidation. Look at paragraph 2. This is the longest paragraph in the fact pattern and the one that is most dense with important facts, every one of which is going to find a home in a good answer. Look at what happened. Richard conveyed all his separate property to the trust. Alicia is the trustee, with full authority to manage the trust and invest its assets. Under the terms of the trust, Richard gets all income for life. Richard, the settlor, upon his death, his child by a former marriage, Brian, the guy who turns out to be the plaintiff in the first couple of calls of the question, and Alicia's daughter by a former marriage, Celia, will receive for their lives whatever amounts the trustee deems appropriate, whether from income or principal. Whatever remains of the principal on the death of the last income beneficiary is to be divided equally among the then living heirs of Brian and Celia. Celia was included as a trust beneficiary only after Alicia convinced Richard that this was necessary to avoid a possible legal action by Celia, although Alicia knew there was no legal basis for any claim by Celia. Okay, well, now we can tentatively answer the first call of the question. Brian can invalidate the trust based on undue influence and fraud. Next, those facts will help us answer the second call of the question also. And thirdly, these facts will give us a number of issues to talk about with regard to Alicia as an attorney. For example, she has committed fraud, and she has unduly influenced her husband to create a testamentary document that benefits her child over his objections. And predictably, we're not going to let her get away with it. Move on to paragraph 3. We learn a few details about Celia. She lived with Alicia and Richard from her 10th birthday until she graduated from college at age 21 in 1990. Richard had earlier expressed an interest in adopting her, but couldn't because her natural father wouldn't consent. After Celia graduated from college, she rarely communicated with either Richard or Alicia. Certainly, no facts there are present to make us any more sympathetic to Celia's possible interest under this trust. In paragraph 4, after the trust is created, and while Richard is still alive, Alicia invested half of the trust assets in a newly formed genetic engineering company, Genco. Well, we've seen similar facts to this before, and we know that this is not an exercise of prudent business judgment. Next, Alicia lent the other half of the trust assets at the prevailing market rate to the law firm of which she was a partner. Well, at least she got fair market interest on this loan. Still, taken as a whole, it looks as if she failed to diversify, and given her apparent manipulation of her husband earlier, we are probably inclined to view with suspicion, to say the least, her loaning part of the corpus to her own law firm. In the final paragraph of the fact pattern, Richard dies in 2000. He is survived by Alicia, Brian, and Celia. Brian is upset with the way Alicia has handled the trust assets. No kidding. He's got plenty of reason to be angry. He seeks to have the trust invalidated, or, in the alternative, to have Alicia removed as trustee, and to require her to indemnify the trust for any losses. And despite my alleged pro-defense bias, this plaintiff is going to win everything, and then we're going to punish Alicia for her professional misconduct. So let's have a look at the outline of issues that I present. Here again, taking the time to be careful and meticulous and to make sure that your legal reasoning is transparent and easy to follow by the chain-smoking solo practitioner who will grade your bar exam. So, show your steps. Let's have a look. With regard to Brian's efforts to invalidate the trust, first we have to establish whether or not this trust is even valid on its face. Then we focus on the undue influence and fraud, and that allows us to reach the conclusion that Brian in fact can invalidate this trust. Next, we ask and answer the question, can Brian remove Alicia as trustee and require her to indemnify the trust? Well, this is the remedies aspect of the question. We focus on fraud and undue influence, then we look at Alicia's conduct as trustee. We focus on her duty of loyalty and her duty of care, and also her potential liability for indemnification. We conclude that Brian can remove Alicia and force her to indemnify the trust. Then, finally, we turn to the PR issues. Here, as often is the case, reasonable people can differ a little bit about how to organize this answer. One could readily organize it around conduct. I choose to organize it around duties: the duty of honesty, the duty of loyalty, the duty of competence and zealousness, and this analysis leads us to an easy conclusion. Alicia should be subject to discipline for her behavior. So it's about time for us to have a look at the answer. But let me pause for just a moment once again to advise you about what we are really doing here. Our goal here is to achieve high scores on bar exam essay questions. It's possible to have all of the conclusions correct and still achieve a failing score on your answer to this fact pattern. What is necessary is for you to do a thorough job as a journalist. Explain exactly what happened. Tell the story in this legal context that your legal education and your work with me allow you to apply, and then, quote unquote, think like a lawyer. Start from the beginning, work your way through carefully, show every step of your reasoning rather than merely reciting a bunch of law and then stating a correct conclusion. Now, please turn to page 1 of my answer and notice how up front I lead with the facts. I explain who Brian is and that he's got strong arguments to get what he wants. Next, we focus on the requirements for a valid trust. And here I find a home for the law. I explain what is required in order to establish a valid trust. Here, I focus on the facts, connect them to these elements, and I conclude on its face, this appears to be a valid trust. But not so fast. Next, we turn to the problems that are caused by Alicia's misconduct. We focus on undue influence first and fraud second. And here, I write 5 paragraphs between these two issues. Have a look at them. This is where you might learn a little bit of technique about essay writing for the bar. Notice that I am merely finding a home for the facts. That means I am not just copying them. Just as I don't recite a lot of law, I'm explaining what the facts mean in the legal context provided by the issues presented in this question. So, notice that I lead with the facts under undue influence about the fact that this trust would not even have been created if Alicia hadn't urged her husband to do it. Alicia is an attorney. Next, we point out the fact that Alicia has unfettered discretion to give income to Celia, her daughter, and that Celia's heirs have equal rights to the remainder as do the heirs of Brian. And the only reason that Celia and her heirs are present at all is because Alicia unduly influenced her husband and exploited her advantage in knowledge of the law and his trust in her to get him to do her bidding. That means Brian can invalidate this trust because of undue influence. But we're not done yet. Now we focus on fraud. There was fraud in the inducement and fraud in the contents of the trust. And here, the use of this language shows a knowledge of the law. We don't really have the time or the need to carefully define all of these legal terms. Rather, we will offer what scant definitions we have time for, but mostly what we're going to do is illustrate our knowledge of the law by sharply analyzing the facts. Look at what happened. Alicia urged her husband, Richard, to create this trust, and she did so with fraudulent intent. She used her knowledge of the law to misrepresent her own daughter's potential right to complicate the distribution of the assets that are going into this trust, when in fact, Alicia knew that Celia couldn't have any legal right, and Richard relied on this misconduct, these fraudulent statements of his wife. So we've got a material misrepresentation and reliance. That equals damages. So Brian can invalidate this trust on the ground of fraud as well. And I think that it is best to point out both undue influence and fraud and to analyze them separately. Not because it's really necessarily any better intellectually, but because it allows us to create an answer that is easy to skim and that is packed with solid content. It is better organized than squishing it all together. So I conclude that both of Brian's grounds for invalidating the trust are strong, and I write in these exact words that they are virtually guaranteed to succeed. Then we consider his remedies below. That requires us to turn to the second call. Can Brian remove Alicia as trustee and require her to indemnify the trust? And here I lead with the facts yet again. Alicia's bad faith is good enough to invalidate the trust. Now he wants to replace her with another trustee and require Alicia to indemnify. His chances of success are good. I focus on fraud and undue influence up front. And we've got more than enough evidence to support her removal, as well as some information that can help us calculate how much Alicia would have to repay. Next, we turn to the duty of loyalty. As a trustee, Alicia owes a duty of loyalty to the trust itself. And all of the facts that we've already considered about fraud and undue influence add up to breaches of the duty of loyalty. Then I focus on the fact that she has lent half of the corpus to her own law firm. Now, I grant that she is obtaining at least market rate interest for this loan, but it seems to me that there is at least an appearance of impropriety and self-dealing present. Next, we turn to the duty of care. And here, Alicia has to exercise prudent business judgment, and she's already used half of the corpus to fund a questionable loan. Now we focus on what she did with the other half. She invested it in Genco, a brand new genetic engineering company. She should have diversified the corpus between these two investments and actively managed the portfolio. Now, fortunately for us, we don't know how the Genco investment has done. By the way, if it turns out to be a smash hit, we pat Alicia on the back, and we then take the income away from her daughter. Still, Richard was alive at the time that Alicia made this investment, and it looks as if Alicia never consulted him and never informed him about what she was doing. And we next turn to indemnification. Here again, we don't know how well this investment is done. If it's done well, there'll be no need to indemnify. Still, we also don't know if any income has been paid to Celia. And if she has paid any, she's going to have to indemnify. Plus, notice the last thing I say under indemnification, a straight remedies issue. If the plaintiff, Brian, can prove fraud, then punitive damages will be available to him as well. And that's what I point out as we reach the conclusion. Brian should be able to remove Alicia as trustee, and if any losses have been sustained or any money paid to Celia, Alicia will have to pay that money back. Next, we focus on the professional responsibility elements of this question. They are simple and straightforward. I think here it's a little better to organize around duties. That way we can have more headings that have legal content instead of factual content. But let's rehearse it quickly. Either way would be okay. With regard to the duty of honesty, we point out that Alicia has used her knowledge of the law to defraud her husband and exert undue influence over him to benefit her daughter from a previous marriage. It is corrupt behavior, and it breaches her duty of honesty and to act in good faith as a lawyer. Next, we turn to the duty of loyalty, and we point out up front, Alicia is acting as her husband's lawyer at the time she draws up this trust. And that means she has a duty of fidelity to his interests. And he stated an interest in not benefiting Celia. But instead of following his wishes, Alicia has gone against them and forced him, basically, to set up this trust to make her own biological daughter a beneficiary as a result of her misrepresentations about Celia's possible power to interfere with the ultimate distribution. That's good enough to subject her to discipline. Next, we point out the duties of competence and zealousness. Now, we often think of zealousness as a duty that is owed in a litigation context, and that's obviously true. But the duty of zealousness really applies to all conduct of an attorney. We're the ones who are supposed to look out for our clients and to be a couple of steps ahead of them to look out for their interests. And instead of being a competent, zealous advocate for her own husband, she manipulated him, lied to him, and ultimately defrauded him and his son. So, clearly, this attorney is a ripe candidate for discipline. I conclude that her conduct was utterly dishonest, disloyal, and incompetent, and she should be subject to discipline. And that concludes a consideration of what I think is a very fair and straightforward wills and trusts PR crossover question.